So today I want to take you through some of the more recent cases in ethics to keep you up to date. Not that anything really changes. Ethics is one of those wonderful areas of law where I don't really have to worry about doing the latest law cite cases or anything like that because the fundamentals don't change, they can't change. It's that simple. And I've been having some interesting discussions in the last little while with people talking about international solicitors and whether they could have an issue when they move outside of Australia and operate in other jurisdictions, particularly those that don't share the same sort of common law, English law heritage as we do. And we're thinking about thinking, well, you'd have to have some interesting justification to have any change to the rule about not lying, not cheating, not being an officer of the court. That would be a very interesting one if you saw a system where your obligation as officer of the court was not paramount. It would be saying quite a few things about the strength of the legal system. So that's where we stand essentially with our ethical rules. They don't change. We just get different versions of their application, and that's what I'll take you through today. And I've tried to pick out areas that will be relevant to you in all your very different community legal centres. I'm assuming you come from the whole range, so I think these will be relevant to all of you, but in application. The first case that I want to look at, and you do have a case list there, but this hasn't actually become a case. Hopefully it won't. And I'm sort of always nervous about naming solicitors or firms or in any way sort of holding up a particular individual. For example, I like to use cases from overseas for that reason, on the basis that New South Wales solicitors are so much better we don't get into strife. Not too often, luckily. Because I think mostly with ethical issues, it is a case of there but for. I think we can all stray into an issue inadvertently. We get so swept up in a matter because we want to get our clients' rights vindicated or whatever is the situation, and we just don't look down for a second and think about the ethical issues that might arise. So it's about training, it's about being aware at all times and having it just in the back of your head that there could be an ethical issue. So this first one actually relates to Donald Trump, which I thought was rather topical, but to one of his proposed heads of department. So this was the Department of Health and Human Services. And this particular nominee was accused through CNN of having had some sort of conflict of interest in that he had purchased shares in a company that was part of an industry over which he had some jurisdiction because he is a congressman. And that was the implication made by CNN, apparently. So, lawyers for this congressman write a letter to CNN. Essentially, you can imagine what it was. It was the allegation of defamation, the cease and desist, that sort of letter. Then they very hastily have to write another letter, and I'll just read it out to you. On behalf of the firm, we apologise for the letter, which should not have been sent by our firm, given our representation of CNN on other legal matters. This will confirm that our firm no longer represents the congressman on any matter relating to CNN. As such, CNN has no obligation to respond to that letter. And this is the real kicker, I think, because it's oh my goodness, please, we want you as a client still. We highly value our long-standing relationship with CNN and very much regret these circumstances. See what I mean about the there but for? I think we can all see how that can happen. In the mega law firms, because they're so separated, and one arm has no idea what the other arm is doing and sometimes can't have an idea. But even in your environment, And I know I've often had calls, the panicked call, because somebody's realised that their client has a few names and they've just run another conflict check and the name has finally come up. What I think this also highlights is the importance of doing your conflict checks at a very early stage, as early as is humanly possible. Because there are instances where even reception staff could take a phone call, find out information about a client, potential client, feed that information into the firm, essentially. Then they get the name, then they make the appointment, then they do the conflict check, and oh dear, there's a problem. So the classic one, I think, is the family law situation, where somebody rings up and says, I want to take my children out of the country temporarily. Is that going to be okay? Can I come and see you about that? Then you do the conflict check, realise that you're acting for the former partner, and that information is vitally useful to your current client. Can you tell your current client? Can you tell? No. And that's what's made quite clear in the rules, that we don't have to have a formal arrangement with a potential client. We can have just that interaction with even reception, frontline staff, but they're giving us that information in confidence. They would be rightly most upset if we then went out and told everyone about that down in George Street. So we have an obligation of confidentiality, but then we have our client, our existing client, to whom we owe the benefit of everything we know. And that's your conflict. That's what you can't get over. Does everyone have as robust conflict check policies as possible? And I say as robust, but there will always be situations where they don't work. Always. But does everyone have the whole office aware of the importance of conflicts and checking, making sure before you get too much information? Because it is very important to keep that in mind always. So that's the Donald Trump moment for this morning. The next case is it is a reported case. This is the case of Linden fisheries. Relates to the Sydney fish markets. Does anyone know that at Christmas time, crabs, you know those things with long tentacles and not much meat in the middle of them, were going for $800 each? I mean, seriously, how could that much crab meat be? That's why I suppose there was this big fight. Sorry, yes.
Sorry to interrupt you.
Sure.
It's a little bit hard to hear you.
Okay.
Sorry,
Sorry, thank you for telling me that, because
I don't want to burden you.
no, what I'll do, I'll stand over here. I hate it when I get to the end of a session and somebody then comes in and says, couldn't hear you. Why didn't you say earlier? Now, if I speak into that, is that excellent? Okay, thank you very, very much. Linden Fisheries was Sydney Fish Market and a very long-standing tenant of Sydney Fish Market. Now, this 25 odd years, they'd had their little stall down at Sydney Fish Markets. They were a shareholder, a significant shareholder in one of the two entities that owns and runs Sydney Fish Markets. Very quaintly in the case, these two entities are called the buyers and the catchers. Apparently that's how it's divided up. Now, what was happening was, in the dispute over the termination of the lease, Linden was suing Sydney Fish Markets, a number of the directors of Sydney Fish Markets and other entities. The directors and Sydney Fish Markets were being represented by different firms of lawyers. And unusually, Linden essentially complained about that. Why they did that was because they were looking at an adverse security for costs order. And so they were looking at how you could reduce the costs that they would have to potentially secure. So very unusual, because more typically it's one solicitor acting for multiple parties and the other side objects to that or raises an issue about it. So the court looked at whether the directors needed separate representation to Sydney fish markets and came to the conclusion that it was absolutely right, that they were separately represented. One of the accusations was that the directors had acted in breach of their duties to Sydney fish markets, so obviously at that point there was a massive conflict of interest. What the court highlighted was that while Sydney fish markets and its directors might eventually come to the same point, and probably would, that everything was absolutely perfect and Fearlands was in the wrong to make any accusations. So there was a common goal, a common stance in that regard. That wasn't what the lawyers were really advising the clients on. It was how they got to that unanimity. And I feel that's a very important point when you have multiple clients or would-be multiple clients. So often they do have a common goal. But if you step back and think about what our role is, it's to provide legal advice on their rights and obligations to get to that common goal. So the typical scenario that's put to me is the intra-family conveyance. So parents are selling, in inverted commas, selling property to children. Everyone wants the same thing, agreed on price, everything is unanimous. They go to the lawyer, the one lawyer, the family lawyer. And the family lawyer is stuck in this position of trying to explain to the would-be clients why it is that they should be getting separate representation, that it would be better to do so. And that's because it's about the legal rights of each party in entering into that transaction. And I think that's a vital distinction. How often do you have situations where you have multiple clients and have to try and deal with that and analyse it? Does everyone have that often? Family law?
Tenancy law as well.
Tenants as well, common tenants in a lease situation. And I suppose in a tenancy situation you could have a head lessee and then... Yes.
We wouldn't in that case, but if they're co-tenants.
If they're co-tenants, yes. And it's important. I mean, I'm not saying in any way that you can never have multiple clients, but I'm saying you've got to be very careful when you have multiple clients. There's always the risk that their interests will not be the same. Anyone else have that situation? Yes?
We often represent residents in retirement villages who are concerned about an action by the operator.
Yes, residents in retirement villages. And that's where I could imagine you could be going along very nicely with a common cause against the operator, and then all of a sudden there's a distinction between, say, the different levels of care and what the operator is offering, something like that. And so their interests could suddenly go every which way, but a lot of commonality. Two stark examples, I think, of where you have to be on your guard at all times. Where you've got more than one client, there is always going to be that risk of a conflict between their interests. Now, the rules do say that if you get the right consent and you set up Chinese walls and various options like that, there's a possibility of continuing to act. I would suggest to you that that possibility is extraordinarily limited. Once you move outside the large law firms with their separate computer systems, their separate floors, their physical ability to manage that sort of situation, I think it's going to be very, very difficult and not worth it in terms of your ability to do your best for your client without distraction. There was one case where a firm had the most magnificent Chinese wall set up. It had electronic this and electronic that. And the court just said, but how does that stop a phone call? And that was absolutely right. It couldn't stop a phone call between solicitors on either side of the wall. So I think for your own sakes, and I know it's harder when you've got the sort of clients you have who mightn't have too many other options, but it's owed to them. And I often have solicitors ringing me from country towns and they're saying to me, well, look, the next lawyer is 400 k's down the road and my clients have absolutely no money to travel. The courts flip that and say, well, we won't allow a small town exemption because that's suggesting that those clients aren't worth the same level of service. And I think that's a very important way of looking at it, that every client is owed our full fiduciary obligations, and we can't have any client who doesn't get that. It's so important. The next case is the Bain case. And this one throws up quite a few issues for us, not least the intersection of the personal and the professional and the implications that can still apply to us when it's a personal matter. This involved a solicitor who had his own family law matter. He was represented by solicitors in that. Very good idea. Everyone's heard the old adage of a fool for a client, I'm sure. Just don't do it. So he was not doing it, but what happened was he ended up giving an undertaking that the life insurance payout from his unfortunately deceased wife would go into his own trust account. For some reason it wasn't going to go into his solicitor's trust account. He gave an undertaking that that was where the $400,000 or $500,000 would go, and that undertaking became reflected in an order of the court. Unfortunately, the money did not go into his trust account. He spent it. And he spent 6 months in jail as a result. The court was horrified at the way he had treated an order of the court as an officer of the court. Interestingly, the people who were going to suffer as a result of his actions, his children, did not want him to go to jail. They were not protagonists in the usual sense. In fact, the main protagonist that the court identified was the court itself, because this was so harmful to the administration of justice. There are about 9 references in quite a short judgment to that exact phrase, and various other versions come in as well. I think if you did a Google search, it would definitely be maxing out administration of justice. The court was horrified at this happening. The solicitor, of course, was rather horrified because it meant that his practice had to close down. He was a sole practitioner. So it had massive personal and professional ramifications for him. It is on appeal, I believe, which will be very interesting to see. But I'm not worried about the ethical side of it. As I said at the outset, I don't see how the court could say much different to the administration of justice is vital. Whether they come to a different conclusion about punishment, sentencing, maybe, but that statement is always going to hold good. I am often asked about that intersection between the personal and the professional. How far are we a solicitor? When do we take our hat off? My general guidance is be very wary if you think you're not being seen as a lawyer. Who has deliberately not revealed that they are a lawyer at times? You don't want to get into situations, do you? You're not at work. You don't want to be identified as a lawyer, and sometimes it's just not the best thing to do, for hopefully not too bad reasons. But I think it's vitally important that we all recognise if we're asked to read over a letter for somebody, if we're asked to witness a document for somebody, just always be careful that that is not legal advice, particularly for, I'd suspect for most of you as well as for me, we don't have the practising certificate and the insurance to do anything outside our jobs. So just always be alert to that, a gentle pushback. I had a lovely experience once where I was talking to somebody who ran a double business of being a law firm and a podiatry clinic. Great business, apparently. But I said, how do you manage that situation where you're doing somebody's feet and they start talking about their legal problems? She said, no problem at all with that. I just tell them the rate's the lawyer rate and not the podiatry rate, and they shut up so quickly. The other point that Bain brings to the fore is the danger of undertakings. Undertakings that end up being personal undertakings on our part and not client undertakings. It is extraordinarily rare in the ordinary course of matter that we as the solicitor should be giving an undertaking. The instances that I would see would be where there maybe is a conflict and some sort of wall is being set up and there will be an undertaking that the solicitor won't discuss a matter. Very difficult, because what is discussing a matter? But always step back and think, why should I give this undertaking? Why is it not my client's undertaking to give? Because once we start straying into giving undertakings that really belong to our client, then we're trying to bind our client as well, effectively. And the client is the last person you can rely upon to do what you expect them to do, to give the correct instructions. So always be very careful. Do people have registers of undertakings or formal policies in relation to not giving them? Is that the case in a lot of your organisations? It might be worth... Not very often. Just in a conflict situation, right. So you do have the warnings given and people are aware of the risk of them. I think that's the starting point. It's just making sure that everyone in the office, because a junior clerk can give as effective an undertaking as the head of the organisation. So just always be very careful that people know if they promise to do something, you will be bound by that promise. And it doesn't have to be in writing, it doesn't have to be called an undertaking, it's just I'll do something, and then you're bound. And we at the ethics department cannot, unfortunately, magic it away. We get people ringing us up saying, oh, I've got this undertaking and it's all a problem. It's like, sorry, you can either go to court to sort it out or you can get the recipient to release you, but that's it. Be careful. Now, I've got a few cases here about proper communications, because it is just so frequent that I see letters written by lawyers to lawyers that are not written in the correct, courteous way. Who's been on the receiving end of one? Yes, for those on the recording end, there was general laughter. Anyone want to share some of the most delightful terms that have been used against them? I've been called some lovely names that they didn't think were quite appropriate to come out of a lawyer's mouth. The first case I have there is Sharky, and that was actually a really nice case in the end result only. Law firm steps into a matter, doesn't have apparently too much information about what's been going on. The other side, their lawyers, have sought an injunction to prevent this new law firm's client from leaving the country because they thought they were a flight risk. And the new law firm writes a letter of extreme disagreement and disapproval to the other law firm, and using very, very strong terms about the behaviour of the law firm. The court felt that the language was so extreme and so not grounded on good evidence that they decided that the letter would be sealed up, not to be opened without a court order. So they didn't want that going down on the record with that law firm. So I think that was a nice protective mechanism by the court, acknowledging that some letters just aren't appropriate at all. And if we do have to make an accusation against another solicitor, we must have grounds for that. We actually have to have a rule now which says that if you want to suggest that another solicitor has breached the conduct rules in some way, you have to have good grounds for doing so. Now, why we have to have a rule to say that is scary in itself. We shouldn't have to have a rule. It should be the case that we would never suggest another solicitor has breached the conduct rules without very, very good reason to do so. And my suggestion always is that you ring them up and see what's going on, because so often there are things going on in the background that will change the view of the world. Ring up first, if you can. I know there are instances where that is not possible, but if you can, do try and ring up the other solicitor and see. Give them a chance. The case of McDonald was a solicitor, again, writing a somewhat intemperate letter to the other firm. This solicitor was acting for a former employee of MS Australia, and there was a fairly significant disparity between the termination payment that the employee thought they were entitled to and the one that MS Australia thought they were entitled to, somewhere sort of $500 versus $20,000. So you can see a slight disagreement there. Now, in this one, the court was asked to consider just how robust we can be. I think we all recognise that that is part of our role, is we have to put our client's matter forward with a certain degree of firmness and robustness. That's absolutely acceptable. The court was looking at a case from the ACT where a solicitor had written a very robust letter, as one court found that it was too robust, the next one said it wasn't too robust. So it was right on the borderline there. And the court was saying, well, if it's in the best interests of the client, for them, if it's not attacking other people outside of that umbrella, then it's possibly justified. I rather think that that's the wrong test. I think the test is perhaps more basic. Is it courteous? That's what it comes back to. So I think going down that route of sort of a test of in client's interests, or is it just a separate rant, it all comes back to courtesy. And that's the test that I think, a higher, more generic test, I think is what we should apply. And I think we all know when something is courteous, when something is distinctly discourteous. The final case on these sorts of communications is the case of Furlong. And that involved a solicitor. It was a dispute over property, mortgagee property. Solicitor making accusations about false swearing of stat decks. Now, I don't like to tell you how to do things that are wrong, but if you really want to get at a colleague, this in this case pointed out, accuse them of dishonesty. It's the best way of upsetting another solicitor, and I think we all would understand that. Honesty is just so integral to our roles that if we are accused of anything less than that, it is just so gutting, and particularly false swearing of an affidavit. As my manager says, there are two ways that you're pretty much guaranteed to get struck off. Take trust money or falsely sign something. Two ways. Don't do. In this case, the solicitor said, I made that accusation on the basis of my client's instructions. Does anyone think that's going to fly? No, that one doesn't fly. Got to do a little bit more digging for yourself. That is always a problem with clients, isn't it? The intemperate instructions, the illegal instructions. What our rules require is that all instructions are competent, lawful and proper. It's a tiny little phrase, but golly, it's a tricky one. If you think about that and apply that to all your clients, how many times do you have a problem with at least one, if not more, than those three requirements? Capacity, huge problem. Lawfulness, is it lawful? Is there something a bit smelly about it? Means we can't get involved in it, can't help them to do something wrong. And proper. That's actually a nice one, I think. I think proper is where all these intemperate communications really fall under. It's not proper to make those overly robust statements that the client often wants. Even if it isn't actually a breach of the law, it's not proper to do so. One rule requires us not to threaten criminal sanctions or disciplinary sanctions as leverage for civil benefit for our client. Always keep that one in mind. So that's where you're in the proper lawful. It might actually be blackmail. Have you had an instance of that one?
Oh yeah, where they assume what the outcome would be, what the judge would decide, and that's when they say this will your client would be liable for all this costs and all this, and that's nothing. That's that.
Yes, a threatening liability for costs when that's very much at the discretion of the court. There was a solicitor down in Victoria who overstepped that line and not only had professional sanctions but had the ACCC involved because it was debt collection matters. So be very, very careful. Sometimes I know it can be a real struggle when you do have the potential of a criminal matter linked to a civil matter. And I remember discussing at length with one solicitor just how they were going to deal with that. And it ended up that the safest way of actually making sure that there was no element of coercion in the communication was that the solicitor was going to get instructions to report the matter to the police first, then write the letter and say, well, we have reported this to the police. Because there was no coercion then, it was in the hands of the police, that was that. Here's the civil matter, we'll resolve that, but it's gone. So that was a fairly extreme solution in that often it wouldn't be something that necessarily is reported to the police, but so that was the best way to make sure there was no leveraging. Because it's so inappropriate to use those sorts of processes, even if it isn't always blackmail. The next case is the Stewart case, and this is a case from New Zealand, so I put that in as a rider to this as to what would hold here. This is the situation where you're dealing with a non-lawyer representative. So in this case it was a conveyancer, but I would imagine, do you often deal with non-lawyer representatives? Obviously family members would be a problem. What about other representatives?
All the time. Legal officers within law firms, finance companies, etc., who aren't lawyers, but they're
Right.
dispute resolution.
Dispute resolution officers, claims officers, people like that, yes. The question is whether we can communicate directly with their clients when they're not lawyers. So the no contact rule, where we can only do so if we have the consent of their lawyer, but what when they're not a lawyer. So the Stewart case involved a conveyancer, and the solicitor acting for the purchasers communicated directly with the vendors, copied in the conveyancer, but things were going wrong, they needed to get something sorted out, and they went directly to the vendors. And the conveyancer was very upset about that and said, you aren't entitled to communicate with my client. And there was one regulator who agreed with the conveyancer, one regulator disagreed, and the court disagreed. So the court said no, the rule only technically applies to lawyers, proper lawyers, practising certificated lawyers. I feel in one sense that reflects part of what the rule is about, and that is that we as solicitors give our client protection. And so if another solicitor were to come in and talk to our client, they would be undermining the protection we give our client and the advice we give our client. But on another level, if you think about that rule, it comes back to courtesy again. If you are dealing with a non-lawyer representative and they make it clear that they want communications to go through them and not directly to their so-called client, then it's probably a matter of courtesy that we abide by that. And perhaps look at ways of dealing with situations where they don't respond. Now, always remember that the rule has an exception. If you cannot get anything out of the other solicitor, if they go to ground and you can't find them and the matter needs to be resolved, you can always send them some sort of communication saying, I am going to contact your client directly if you don't get back to me. Give them a bit of time, and then you are entitled to contact their client. I would follow the rule absolutely to the letter, just because that will protect yourselves, but there is always that exception there when you need it, and quite often people do need it. It is amazing how discourteously solicitors will not tell the other solicitors that they're, for instance, no longer acting. They will just disappear and no communication will be entered into, seems to be their rule. Never be one of those solicitors. But always remember, there is an exception. Whether Stewart would be held the same way in Australia, I'm not sure. I suspect it would be, but until we get some jurisprudence, but we don't really want jurisprudence because that means the solicitor's done potentially the wrong thing and has all the problems with that. The next case is not actually a case. I don't think there has yet been litigation about it. Whether there ever will be, who knows? This is the Mossack Fonseca issue last year, the Panamanian law firm whose disgruntled employee emailed all those details about clients to the German media. I think what horrified the world most is the breach of confidentiality of a solicitor. Because I feel that while we are denigrated so often and so unjustly, the one thing people expect of us and rely upon us absolutely is confidentiality. So it was the horror of a law firm's information being released. Obviously there were all the interesting bits about who was actually a client and all the rest of it, all the gossipy bits, but I think the fundamental there was just this feeling that one of the last repositories of confidentiality, despite Google, despite WikiLeaks, despite all that, was your lawyer. And in this case, that didn't work. Family members are a real risk in that area. The very helpful parent or sibling who rings you up and wants to know because they're helping out. How do you deal with a family member who wants to know who's helping, who appears to be helping? How do you deal with them?
Tell them to get the client to call.
Tell them to get the client to call. Yes, that could be a very safe way of dealing with it. Because obviously you don't want to upset them, but it is important that you recognise they're not your client and all your confidentiality is owed to your client. If they authorise you, that's fine. You have to be careful just how far they authorised you. Always a risky one. So stick with the client. The next case is Blackwatch. That involved a property developer suing their accountants over whether, and I'll get this right, the applicability to the acquisition of commercial property of the margin scheme for GST. Okay, so we're not dealing with the most fascinating argument here. Margin scheme for GST. It's times like this when you're really pleased you're not a tax lawyer. Now, the accountants then turned round and claimed that the solicitors acting for the developer, they had also given advice on this, the cause of the problem, and they were also at fault. So essentially this law firm, while acting, had a very close personal stake in the matter. As the court said, it wasn't so much about a financial interest as a personal or reputational interest for this law firm that was really concerning them. And the courts are always concerned about a personal interest in a matter, because while it's rare that you see very obvious examples of where personal and professional interest have actually collided, at least in the judgments I've read, it's the risk of that occurring, it's the appearance of that occurring that the courts are so adamant about avoiding. The risk that somehow the solicitor will be inclined to not be perfectly honest, even if subconsciously, that they've got that stake of their own in the matter and they can't be independent. And that's one of the requirements on us, that we are always independent. The solicitor who acted for his parents, who were suing their financial advisor, was forced to cease to act because the court said, we can't rely on you. We can't be sure that your loyalties are to the court first and to your client second, and then yourself shouldn't be involved in that. Do any of you have situations where you're perhaps not necessarily personal interests, but for instance organisations that you're involved with might have a slightly different interest to the client themselves? You get those situations at all? Yes.
It's a situation, you're up against a lawyer who's acting privately, and you think that they're actually taking a particular course of action because it racks up massive fees for them.
Yes. Costs are always a source of tension. What I usually say to people is that fundamentally, and not for your area, but fundamentally, we're entitled to be paid for the work we do. That in itself is not seen to be a conflict in itself, but you can see how any deviation from that basic premise, for instance, a contingency fee arrangement, conditional contingency fees and ban, a conditional fee arrangement where the solicitor's costs are riding on the outcome of the matter, that's where the courts have expressed concern, where somebody is unreasonably racking up fees, perhaps to make your client, if they can't afford it. So I think family law, it's rife in family law, isn't it, where one side will just take every single point to try and bankrupt the other side. So those sorts of situations, yes, where the solicitor is acting in a way that means that they've got a different stake in the matter to just the straight out, I'm paid a fair and reasonable amount for what I do. That's where there could be strife. Yes?
What about the circumstance where a solicitor has missed a time limit and there's an argument that can be made about having, reason pause or whatever, exceptional circumstances to get the client over the line, but the solicitor obviously has the vested interest in not having missed the time limit?
So where the solicitor has made a mistake and missed a time limit, and the client needs to have an argument brought to have the time limit extended, that's a classic conflict, I feel. As soon as a solicitor has made some sort of error, then what is the advice to the client? You should sue me. or you should do something adverse to me in some way. And how can a solicitor continue to act in that sort of situation? Wherever you're notifying your insurer, and I think you self-insure, wherever you're notifying your insurer, then it will be very difficult to continue to act in that situation. So yes, a missed time limitation is a great example. The case of Rosen is a former client situation that I think happens quite often. Family law solicitor who has acted for wife in her family law proceedings, husband in his family law proceedings, and then wife against husband in their family law proceedings. I am sure you've all heard of the situation of the Lonely Hearts waiting room scenario. It does happen for family law experts quite a bit, I understand, and creates absolute havoc for them. Because as soon as two clients partner up, then that becomes sort of mingled matters and who are they acting for. Anyway, so in this situation we've got wife saying, it's fine, you can act for me, husband saying, not a chance. Wife's arguments are, well, when my husband was divorcing his former spouse and utilising your services, solicitor, I sat in on every communication between you. I knew it all. I was there at all the conferences. So where is the danger to my husband's information? Because I've got it all. The court thought that unlikely, that the wife would have been privy to everything. But the court then took a very simple and strict view and said, well, the solicitor has received confidential information and it's detrimental to the husband's material, therefore the solicitor can't act. That is the general approach by the courts in these circumstances, even where the solicitor has had a lot of where the other party has been there for all or most of the communications. And one of the other reasons that the courts will say why the solicitor can't continue there is because the solicitor heard the information in a forensic way. The client didn't. So the solicitor will have understood the legal ramifications of what was being disclosed, which their client doesn't necessarily have the benefit of. And the other argument that the courts will bring to bear is the appearance one. It just looks so bad. And that's always lurking there at the back of any of these situations where it's grey whether a solicitor should continue to act or not. Does it just look so bad that we do a great disservice to our profession and to administration of justice, coming back to the Bain case, by continuing to act? Will it really mean that our clients respect a decision, for instance? That's something we've always got to keep in mind. When people ring me up and say, it just doesn't feel right, and we explore it a bit further, and there's possibly grounds for continuing, and just going, but it just doesn't feel right. It's like the proper instructions. It is better not to continue in those circumstances. Now, Gillam involved a solicitor who'd taken on additional roles. So it's a fairly similar one to Rolzan in that it involved a family solicitor who'd done a lot of work for the family over the years and then is asked to represent one spouse against the other in the family law proceedings. The solicitor in those circumstances essentially becomes part of the asset pool. Have you noticed that happening? You're part of the assets to be divvied up amongst the parties. And there was even one case where the conversation between husband and wife was set down in the judgment, and it went along the lines of, oh, who's going to get the solicitor? Do you want him? No, you can have him. Is that all we are? I think for a lot of clients, that is all we are. It's like, I divide down here, family Bible that side, solicitor that side. So, in Gillam, solicitor trying to act for wife against husband, who's separately represented. But the sting in this one is that the solicitor, concurrently with representing the wife, is an attorney under a continuing power of attorney for the husband and an alternate executor in the husband's will. And the court thought, no. Just a few too many roles here and a few too many fiduciary duties sort of going crash together. Which brings me to a point that I think is most important to always consider. If you are ever asked to take on additional duties beyond the strictly, I am your lawyer, I provide you with legal advice, are any of you put in that sort of situation? A lot of solicitors do get themselves named as executors, like in this one. Is that something that you come across frequently or not? I'm hoping not. No? Good. It makes life a lot easier. What I think you will be asked to do though, and this is taking on additional role, I suspect you're often asked to be counsellors, aren't you? Mm-hmm. Always accept that our training does not mean we are the world's best counsellors. We are not expected to be the world's best counsellors. We might become the world's best counsellors because we do have the expertise, the experience, and we know a lot about how people react to certain situations. So I'm not in any way saying we're not good at it. And I've seen people who are wonderful at it. But don't ever feel you have to take on an additional role that is outside your comfort zone and could lead to conflicts. I think counselling is in that sort of grey area, but you've always got to recognise that there's our legal role to that point, then there's the additional roles that we might get involved in. I have solicitors ring me up and say, my client has no one else. Can't I be their guardian? Well, you've got to think so hard about whether you can take on that role. Are you going to end up with a conflict? And it is highly likely you will. And then you can't do either job properly. Solicitors who have clients threatening to kill themselves, they're worried about how well they can judge whether that is a real threat or not. Perfectly valid concern. But we're not expected to be counsellors. We're not expected to be lie detectors. We're expected just to be good, reasonable solicitors who have a very reasonable concern that somebody is going to do harm to themselves or someone else, so we report it. Whether it's confidential information or not, we can report it. So don't be worried that we're expected to be more than solicitors. We are not in those sorts of judgment situations. Final two cases. Wilson. Wilson's a very good case to read about the alienation of certain participants in the court process. And I'm sure you've all had experience to this and have strategies to deal with it, because you're dealing with people to whom the court is a very foreign environment. In this case, a mother had had her child taken from her by a department and she was trying to get her child back. Highly stressful and emotional for her, as you can imagine. And she's in the very foreign environment of the court. And what she's seeing is the barrister for the department saying good morning to the magistrate, saying good morning to her, and when she didn't respond because she's just about to be grilled by this person, she doesn't know what to do, the barrister apparently was turning to the judge and the magistrate and almost implying, oh, well, you can see what we're dealing with here. There was almost that implication. And as the court said, it was not intentional, but the implication, particularly to a very susceptible plaintiff, was there. There had also been conferences between the bar and the bench which excluded this plaintiff, and so she was feeling like she was not an accepted part of the process and like her views were not really going to be valid in this process. So this is where we have Justice Palmer say no one should say good morning. It is not right to say good morning. It is not right in any way to suggest that there is some familiarity between the bar, the bench, and any of the legal practitioners that could alienate a non-practitioner. Now, that's a tricky one. If the judge or the magistrate says good morning to you, what are you going to do? Stand there and go, probably not. But you've just got to be mindful of it, as do they, and they are. So always think, how does this look to the new player who's dreadfully emotionally involved and upset? Does it look right? And this will guide your interactions with solicitors acting for the other side as well. Do you go to the coffee shop afterwards as your client walks past? Probably a very bad look, even if you know them really well. Went to uni together. Just always think of that. Have a case of Burnside. This is from America. And I say that because it's important that America tends to... Oh, sorry, the question
Sorry,
is...
I was just going to ask, what was the outcome in that case that Wilson?
In the Wilson case,
What did was she successful in arguing that the council should continue to act, or what actually happened?
in the case before the Supreme Court, so it got removed to the Supreme Court, I don't know if the barrister was then the same barrister. So Justice Palmer was commenting about what had gone on in the magistrates' court at that level, and I don't think it was the same barrister there. But anyway, I mean, he was obviously managing the situation and making it abundantly clear that it was an impartial situation. There was no improper familiarity. So an interesting one. I'll go back and read it. But do all have a read of the case. It is a very interesting case for what Justice Palmer says. So the Burnside situation, again, it's not actually a reported decision from America, but it's just talking about appropriate court behaviour from another angle. I'm just getting the 5-minute wind up from Laurel. I'll be right on time for you. Attorney, not solicitor, attorney, we're in the good old US of A, and they've just managed to have their client's conviction for murder overturned. Client has spent 11 years in jail, they're now being released. It's a pretty good moment. And so the attorney turns to their client, just as the judge has delivered the verdict and left the court, says, "Let's have a selfie." And of course they take the selfie straight onto Facebook and it goes viral within 2 seconds flat. Judge finds out about it straight away, rings up the attorney and says, "You get that down off Facebook straight away," which he does. But of course it's too late. Judge is then interviewed afterwards, and it's being America, they're a little bit more prone to interviews. And he says, "Well, look, I was obviously very concerned about the identity of the jurors because they should remain anonymous and they might have been in the photograph. I was very concerned about the victim's family and their sensitivities in this situation." But he said, "I wouldn't have done it, but then I'm old school. Is this the new accepted?" I would suggest to you it's definitely not accepted in Australia. But I think we've got to recognise that what upholds the appearance of justice in one generation may well change. I mean, I dressed like this, with the pants on, I wouldn't have been seen 20 years ago in courts. So we do get changes, but I would suggest to you that you are not at the forefront of the changes. The final one, just to bring us home, is not a case. It's a law student who doesn't get it. The Guardian newspaper in England runs this consumer advisory helpline. And email them in with any issues you might have about consumer affairs. So be it your plumber, your doctor, your lawyer, if you have an issue with them. I suspect it's a bit of a name and shame situation. Email comes into the Guardian. "I decided to buy a legal essay from an online essay writing service. I paid around £200 for something I was promised would be the standard of a credit degree. I was sent an appalling essay that didn't live up to standards. Demanded a refund, offered a revised version," that goes on. Love this bit. Please help me to protect other students from being caught. Caught from what? Priceless. The Guardian weighs in and says, we're not in a hurry to get your money back, sorry. Funny that. Website is apparently not a loan player. Students, avoid these websites. You will not only lose money, but could also jeopardise your academic career. Then we get the regulatory authority weighing in too, very rightly. Use of these types of websites not only raises serious questions about whether an individual is meeting the standards required, but also whether somebody has quite the right character to enter the profession, where honesty and integrity is crucial. Apparently, cheating is so rife in certain law schools that, because, I mean, you can have your gadget just downloading everything. What they do now is they put drones up above exam rooms to block telecommunications coming in and out. That's what they have to do. The irony is that one of the latest cheating examples that I've heard about was a barrister, not us, barrister, who decided that they were going to cheat on their bar ethics exam by stuffing the notes down their pants the old-fashioned way. Yes, there are people out there who perhaps don't quite get their ethics, do they? So I hope after this I've reassured you all that you're all on the right track with your ethics. If you ever need to, feel free to ring our ethics hotline. We are there for you. Never say, I'm sorry I've never had to ring you before. Never ever apologise. You keep me in a job, which is great. Thank you all. And I do feel it's a lovely service we can offer, if only to get that beautiful statement, which I think makes my day, I'm going to sleep tonight. That's a really good thing to be told, and I'm sure you often get that too with the sort of clients you're dealing with. It's a great feeling, isn't it? Thank you all for your attention.